The question is, this House do now adjourn. Simon Hatch.
Thank you, Mr Deputy Speaker, for this opportunity to debate parental alienation. I've spent much of my time in this place investigating and exposing allegations of child sexual abuse. Politicians, the media and the state were too slow to highlight that type of abuse. I believe that parental alienation is another form of child abuse which has gone both unreported and has been under-discussed. This is abuse which is not properly recognised by the United Kingdom Government. While Westminster remains silent on this issue, parents and children suffer. I believe that government and the courts need to recognise parental alienation as a form of emotional abuse, and as such they need to step up efforts to prevent it occurring in some circumstances punish the perpetrators. Sadly, this is an issue rarely talked about in Parliament. I do not believe there has previously been a debate on it in this place, and that there has only been 8 questions asked on it since I entered this place in 2010. I hope to use this debate as an opportunity to raise awareness and start a discussion about parental alienation. Mr Deputy Speaker, I should attest that I come to this topic not as an expert in the subject, but certainly as someone who has experience of parental alienation. My mother could be accused of such a thing. When my parents separated when I was 5, my mother portrayed my father, perhaps on occasion faithfully, in a very poor light. In contrast, my father would refuse to say anything bad about my mother. So, Mr Deputy Speaker, I have some experience which I think is worth sharing. But for those who do not have first-hand experience, I will explain what is meant by this term. Parental alienation is the deliberate manipulation of a child by one parent against the other parent. Often this occurs after a couple have separated. According to the Children and Family Court Advisory and Support Service, CAFCAS, parental alienation is responsible for around 80% of the most difficult cases that come before the family courts. CAFCAS also estimates that 5% of children involved in divorce or separation will experience some level of parental alienation. However, this figure seems incredibly low for what I believe to be a more widespread problem. Despite these shocking statistics, the United Kingdom lags behind many other countries in the world in dealing with this issue. It isn't recognised in the lower courts, and while the higher courts acknowledge parental alienation occurs, many family rights campaigners feel the courts do nothing about it. While there have been small steps in the right direction, progress in the UK has been far too slow. In part, this controversy is down to parental alienation syndrome, a hotly contested psychological condition. The syndrome is not recognised by the World Health Organization and has been tossed out by some child abuse experts as junk science. Mr Deputy Speaker, I'm not going to get into the nitty-gritty of this psychological debate. That is for specialists to discuss. But what I will say is that it does matter if you want it doesn't matter whether you want to label it as a syndrome or not. It's still a problem for families. I will indeed.
For his exploration of the issue. And would he agree with Mr Justice Mumby, as he then was, a High Court judge, now President of the Family Division, judging several cases, many cases on family and contact disputes, when he said that the actual cause of these problems is the delay in the court system, the court's failure to challenge the groundless allegations against a non-resident's father, and the court's failure to get to grips with defiance of contact orders and child arrangement orders, the failure to properly enforce against breach. Would he agree that that's really at the cause of some of these problems that he's talking about?
I thank the Honourable Lady for her intervention, and I know that she has a good knowledge of these very issues from her time before coming into this place. And I think she makes an extremely good point, and it adds to the discussion and debate that I hope we will continue to have around this very subject. I'm sure we'd all agree that it is not normal for a child in a short space of time to go from loving a parent to seeing them as an object of hate. To quote Dr. Amy Baker, a developmental psychologist who has written extensively on parental alienation, and I quote, "Children do not typically reject a parent, even a relatively bad one, unless they have been manipulated to do so." Manipulation can take various forms, and some acts may even be unconscious. For example, if a mother is anxious about their child going to visit their father, the child may pick up on this and begin, for perhaps no other reason, to worry themselves. The odd comment in front of their children about the other parent's financial situation, or inability to stick with plans, or other mild forms of parental alienation. While such actions are unlikely to have a serious impact, it is nonetheless worth keeping in mind that children are very impressionable and that parents must watch what they say around them. In more destructive cases, the manipulation takes a very nasty form. The manipulator can poison the child's mind with biased accounts of why the marriage failed or the unpleasant details of the divorce settlement. In the more severe circumstances, a parent may restrict access to time to the other parent so that a proper relationship cannot be maintained. This type of parental behaviour can result in the child being uncharacteristically rude to the target parent, refusing to see them and even making serious but false allegations against their mum or dad. Often this is carried out by parents seeking revenge against their former partner. Their children are maliciously used as a weapon in this battle. For the target parent, the sense of loss and pain can be unimaginable. For the children, who are innocent bystanders, the effects in the present and the long term can only be negative. We know from evidence that bad relationships within families are bad for child development. Separation already has its difficulties, but if it's marred by manipulation and hostility, this will undoubtedly impair a child's mental health, emotional well-being and academic attainment. Indeed, it is likely that a child who is manipulated against one of their parents will engage in such practices when they grow up and have children of their own. I must say, Mr Deputy Speaker, that I have had to work at avoiding being negative in conversation with my two youngest children since my second marriage broke down. Thankfully, my second wife Karen and I, for all our differences, work really hard at putting our children's emotions first. This is down to good and regular communication. But, Mr Deputy Speaker, I can understand how a parent can slip into the milder forms of parental alienation. So this, I believe, highlights the need to raise awareness. Since this debate was announced, I have received a number of emails from victims of parental alienation, and I'm sure after this evening I will receive more. Of course, it would be unwise to take these accounts at complete face value. Such cases are often complex and there is always two sides to any story. However, I can believe that many of the tales which have been recounted are experienced by many parents up and down the country. Last month, when I tweeted an article about parental alienation, I was surprised by the response I received. This is an issue that most people outside Westminster are aware of, though they may not well use the term parental alienation. I know a few of those who got in touch said they'd be watching this debate, and I'd like to thank them for sharing their experiences and would urge them to share their experiences with their Member of Parliament. I'd also like to make a few observations before I share some of the more high-profile cases which have been reported on. Firstly, many fathers' rights campaign groups have rightly been campaigning on this issue for many years. Understandably so, given the trauma many fathers have to go through to gain access to their children after separation. However, it's important to note that mothers can be both the victims of parental alienation as well as the perpetrators. Additionally, the manipulation may not come from the parent who has custody over the child. Indeed, a mother or father who sees their child only at weekends could use that limited contact time to poison the mind of their child. Moving on, Mr Deputy Speaker, given that we know the problem affects many families, it is surprising that there are so few documented accounts. Last year, the BBC's Victoria Derbyshire show highlighted the case of a girl whose father manipulated her against her mother. Emma, not her real name, went to live with her dead with her dad 2 years after her parents separated. He deliberately blocked her and her siblings from seeing their mother. The father blamed the mother for the breakdown of the family in front of the children. He told his children their mother was a liar, a drunk, disinterested in seeing them, and that she no longer loved them. Emma was subject to this abuse for 5 years, but was none the wiser. As she told the BBC, and I quote, "With me only being 9 to the age of 12, I didn't know better." Emma's father blocked her attempts to see her mother until Emma eventually ran away. She managed to reach the home of her aunt and call her mum for the first time in years. She now lives with her mother and has cut all ties with her father. She now questions how her father can look after children. While the children are often unaware of the abuse they are being subjected to, the parent being vilified is all too aware. Miriam's case, again not her real name, highlights the suffering experienced by such a parent. Her case is particularly harrowing given the serious sexual allegations made against her by her son after her husband told her she would never see her child again. Miriam denied these accusations and they have since been dismissed by the court. Yet she did not see her son for 592 days. And now her son will only consent to seeing her under supervision every 6 weeks. She is losing hope that she will ever have a meaningful relationship with her child ever again. She told the Guardian newspaper, and I quote, "My son has been so severely manipulated by his father that it may not be until he has his own children that he comes back to me." I know of one mother who had her children stealing jewellery and underwear from the separated father's home. She encouraged them to write graffiti there and even had them put hair removal cream in the shampoo bottles at their father's house. These are some of the more extreme examples of parental alienation. So what can we do going forward? It seems that there is a lack of information out there about parental alienation in the United Kingdom, and therefore I believe there needs to be further investigation. Parental alienation needs greater recognition of this by the UK government, and the family courts need to record parental alienation as a specific issue. Without such data about the scale of the problem, it is difficult to recommend a solution, let alone monitor the impact of any measures the government might decide to introduce. When considering this matter, the government should also consider a variety of measures, from investing in initiatives to prevent or stop this form of abuse in its early stages, to programmes to support victims, as well as changes in legislation to ensure in the most extreme circumstances, parents who abuse their children in this way are punished. Investment in early prevention efforts must be prioritised and better guidance given to the courts, social workers and all those who have children under their duty of care. I believe the government has already funded a CAFCAS pilot scheme to provide therapeutic programmes relating to parental alienation. I would be keen to know from the Minister how this pilot went and if the government plans to continue to expand the programme. I would also urge the government to take on board the concerns of Joanna Abrahams, the head of family law at Setford's Solicitors, who has expressed concerns that cuts to legal aid will prevent parents from accessing justice in regards to this issue. Parental alienation is recognised in the US and Canada. It is illegal in Brazil and Mexico, and parents in Italy who manipulate their child can be fined. It is also worth the government exploring these different models to see how best practice can be adopted here in the UK, and I hope the Minister can liaise with his counterparts in these countries. This is an issue which has a serious impact on our children. It is a crying shame that this form of child abuse is all too often going unrecognised and unreported. I believe the issue of parental alienation wants further debate here in Parliament, and after which we need the government to take further action. Finally, Mr Deputy Speaker, one of the most immediate and simplest ways we can improve the situation is to raise awareness, making both parents conscious of the damage parental alienation can do to their children. Mr Deputy Speaker, we can all help raise awareness by doing more next month, on the 25th of April, when we mark Parental Alienation Awareness Day. Thank you, Mr Deputy Speaker.
Well, Mr Deputy Speaker, can I start by just congratulating the honourable gentleman for securing the debate and also for the very interesting and thoughtful contribution which he made. I think it's right to say at the outset that the government is considering family justice matters at the moment with the view to having a green paper later this year. And with that in mind, he's highlighted an important concern. I was also sorry to hear of his own personal experience of parental alienation, which must make this an issue of particular concern to him, and I think the House will have been moved by that. I'm sure that everyone in the House will agree that parental separation is one of the most traumatic events for a family. It affects the child, it affects the parents, and many separated parents do manage to overcome that agony of separation and manage to work out child arrangements in a way that values and encourages the ongoing involvement of each other. And the Honourable Gentleman mentioned his own experience of doing that. But there are other parents, though, who, for a variety of reasons, find themselves in conflict with each other when faced with the need to make these important decisions together for the future of themselves and their children. And all too often the needs of children are lost in that emotional turmoil. The breakdown of a relationship presents its own difficulties for children. And the emotional upheaval of separation is made worse if one parent, and often this is, as was said, the parent with whom the child resides, but not always, but if that parent seeks to turn the child against the other parent and make them appear anxious in their presence, then it makes the experience that much worse. And while there's no generally recognised syndrome, as the Honourable Gentleman mentioned, it's an issue of contest, but although there isn't that generally recognised syndrome of parental alienation in this jurisdiction, it doesn't mean that it's a problem that is unrecognised by the family justice system. What matters is not whether it's a syndrome, but what the impact of it is on the child. And the government is aware of the difficulties that a parent can face when the other parent seeks to alienate them from the child's life. And I'm sure honourable members know this from their own constituency work, because it is a point that comes up in surgeries. Now, such behaviour can never be acceptable, and it does have a traumatic effect. Like domestic abuse, it can intensify the emotional harm to children. But it is something where the law takes the matter seriously, and there are mechanisms to robustly address it when it features in child arrangements cases before the family court. Now, when a parent applies for a child arrangements order, determining with whom the child is to live and for how much time, that the court must by law presume that the child's welfare will be furthered by that parent's involvement in their life, unless there's clear evidence to the contrary. So when making any decision about the nature of that involvement, the child's welfare is paramount, but that presumption applies. And this position contrasts starkly with the issue we're debating this evening, involving parents who unilaterally seek to undermine the importance of that law, which attaches importance to both parents' involvement, always assuming that it is safe and in the child's best interest that that should be the case. Where the court's dealing with child arrangements dispute, the Children Act of 1989 sets out what's known as the welfare checklist, and this includes having regard to factors such as the ascertainable wishes and feelings of the child concerned, commensurate with that child's age and level of understanding. And if the court is concerned about what those wishes genuinely are and the feelings involved, then the court can request the Children and Family Court Advisory and Support Service, CAFCAS, to prepare a welfare report about the child's wishes and feelings, as well as any other matters relevant to the case. I'm very happy to.
I'm very grateful to my right honourable friend, and I apologise for not being at the beginning of the honourable member for Rochdale's speech due to it coming rather earlier. My right honourable friend is making some good points, but isn't it the case that the problem with child arrangement orders, which are a diluted form of the shared parenting principle, which should have been in the Children and Family Bill, is that the resident parent usually can game the legal system by not abiding by contact orders repeatedly. The non-resident parent constantly having to go back to court, not seeing that child, so over a matter of months that then becomes years, that child does not know that parent anymore, and therefore that child's wishes and feelings may be, I don't know that parent, therefore I don't want contact with them. That actually is the real cause and the most common form of parental alienation.
If my honourable friend will bear with me, I think I basically cover the points that he's making in my next remarks. So, but if not, I give him full licence to have another go. But CAFCAS is a professional social work organisation, and its practitioners do understand and recognise the potential for what's often called implacable hostility. And this can be, as was said, by a resident or a non-resident parent in a child arrangements case. CAFCAS practitioners are professionally qualified social workers, a minimum of 3 years post-qualifying experience, and they are aware of the potential for children to be influenced by parental views, and they're alert to the possibility of parental alienation throughout the case. Where the child presents adult themes or language, the CAFCAS practitioner will explore these and report on such matters to the court. And of course the idea is to try to intervene as early as possible, a point made by my honourable friend for Fareham. CAFCAS has a range of tools available to assist its practitioners in assessing the presence or the danger of alienating behaviour, and these include a tool for use in direct work with the family, where the child rehearsing adult complaints or describing parents in wholly positive or wholly negative terms will indicate their exposure to alienating behaviour. There are other measures that can be taken. In highly intractable cases, the court can make the child who is the subject of the proceedings a party to the case with their own representative in court, as well as a guardian. And this will ensure that their wishes and feelings are fully heard and that they're properly investigated. The government recognises, of course, the potential for parental alienation to continue after an order has been made setting child arrangements. And a parent who has attempted during the proceedings to alienate the child against the other parent and failed may then seek to frustrate the operation of the order. The court does have a general power when making a child arrangements order to direct CAFCAS to monitor compliance with the order and report to the court. And a parent may also apply to the court to vary or revoke the order. Now, where there is wilful breach of a child arrangements order, the court does have powers to deal with this. It may require the person in breach to undertake unpaid work, to pay a financial compensation order where, for example, a parent has spent money coming down for an occasion to see a child and then from another place it's cost money. That sort of compensation can be granted. It is a contempt of court not to follow a court order, and there are punishments available such as fines and imprisonment. But the court does have to consider the reason for the breach, the welfare issues, including the child's welfare, when deciding whether enforcement action is necessary to secure the other parent's involvement in a child's life. Well, I'm just going to come on and finish the point that he was making, if I may, and then I'll obviously give him an opportunity. But I was going to say that in an exceptional case, the court could decide to change the child's residence to the non-resident parent. And as he knows, I've practised in the courts, and I have actually been involved in a case where that happened. It was such an intractable, long-running case. One parent was not prepared to give any time to the other parent with the child, and in the end the judge did transfer over the order. I have to say it wasn't a great success, but it does show that it is a remedy that's available, which is a very powerful one indeed. Of course, it's a profound change for the child, and it can only be contemplated if their longer-term welfare needs outweigh the short-term impact on their well-being. But it is available, and of course in some cases it is an effective option. Implacable hostility and alienating behaviour by the resident parent are difficult issues for the family court to address, very distressing for the parent on the receiving end, and we do need to understand something about the nature and scale of the problem. Now, there is a research study that was done by Professor Liz Trinder of Exeter University in 2012, where 215 enforcement applications relating to child conduct orders were looked at in detail. And it was found that alienating or implacably hostile mothers represented a very small minority, about 5% of the cases. More often, the enforcement cases involved parents in continuing high conflict with each other, and that was preventing them from making arrangements which worked in practice. The second largest group involved cases with significant ongoing welfare concerns, and then finally cases where older children just wanted to reduce the amount of time they were spending with their parents, in effect, wanting instead to take other activities. And I can say, as somebody who's done some of these cases, that sometimes the allure of the football pitch or the friends down the road, it does get in the way as the children get older. I do not for one moment wish to diminish the impact of parental alienation when it occurs. As I've already made clear, such behaviour is unacceptable. It's important to understand that what may appear to be alienating behaviour by a resident parent may in fact be the result of other concerns. And so it's a very mixed, complicated picture. But broadly, I would like to address the perception that the family justice system contains an inherent inequality, which I think is his point, but I'm going to let him have another go if I'm wrong, against fathers seeking to live with or spend time with their children. As I hope I've explained, the legislative framework governing child arrangement orders and adjudication of disputes by the family court is gender neutral. It's focused, and I think this is right, on the welfare of the child as opposed to any perceived rights. Each case is determined on the facts and the individual welfare needs of the child by an independent judge assisted by experienced Kafkas practitioners. Judges, for their part, recognise the far-reaching nature of the decisions they make for those involved. And I think it's just worth reflecting, and I certainly know of cases where there has been this sort of appalling behaviour, but later on it's come back to bite the party that was involved in it, because the child has not accepted this in the longer term and has wanted to know both their parents.
The Minister's been very generous, and I do want to have another go, because he's making some very good points. But to come back to the point of what penalties there are available, and he mentioned imprisonment. Well, of course, in the vast majority of cases, that would fail the welfare checklist for the child in the 89 Children Act, because it's not in the best interest of that child for his or her parent to go to jail. So could he, I don't expect him to do it now, provide us with some figures as to on how many occasions meaningful penalties have been brought against somebody who is a serial frustrator of contact, this form of parental alienation, and how many cases of transfer of residency of a child, because I think he will find, notwithstanding his single case, that the actual number is minuscule. And that is the nuclear option, that is the deterrent, but it's not used.
Well, I'm always very happy to discuss these matters with my honourable friend, who's very knowledgeable in the area of children's protection and also, I think, takes a particular interest in a range of social and caring matters concerning children. And I'm more than happy to look at what information is available for him. And I was also going to say that it is true that we have done some work looking at pilots and particular examples, and also the Department for Education, they have a series of initiatives which they do, not all about this particular issue, but all in the field of family justice. And so I will look to see what further information I can give the honourable gentleman from Rochdale about that particular occasion. Scheme. Now, the law doesn't grant either parent any right to any particular amount or pattern of involvement in the child's life. Parental involvement may take many different forms, from staying overnight, one end of the spectrum, to indirect involvement through letters and cards. And of course, it often depends on the geographical circumstances of the parties too. But if the court determines that a particular arrangement is necessary to meet the child's welfare needs, for example, a shared residence arrangement, it can make an order to that effect. And I'm sure the House will agree with me that the welfare of the child, including any concerns the court may have about safety, must always come before the wishes of the adult parties. The current law does give the court wide discretion to address the range of welfare issues that can affect children. And I'm conscious that this is an issue that transcends party lines, as we've seen tonight. It's a very important issue for those fathers who seek to maintain involvement in their child's life. I hope that I've addressed many of the aspects of concern about parental alienation that naturally do concern members in the House. And in concluding, I would like to thank everybody who's made a contribution, the honourable gentleman, of course, for calling the debate and making a speech, but the interventions as well, which have raised important points. The government doesn't have plans immediately to depart from the current law, which puts children's welfare first and foremost when family court considers matters affecting their lives and futures. But, as I said at the beginning, we are giving consideration to what further changes may be needed to the family justice system, and will be seeking views on our proposals in due course later this year. And it may well be that that will offer an opportunity to the honourable gentleman and others to set forward their concerns if they feel we haven't gone far enough or there's other matters that we need to consider in detail. So in the meanwhile, I will certainly reflect carefully on what has been said in this debate tonight.
The question is this House to now adjourn. As many of that opinion say aye.